If you are a naturalized United States citizen, 2026 may be the most important year for your immigration status since the day you raised your right hand and took the oath. Over the past several weeks, headlines, social media posts, and viral WhatsApp messages have been spreading one alarming claim after another: that the Trump administration's new immigration policies could put naturalized citizens at risk, that citizenship is no longer secure. The denaturalization cases are quietly expanding behind the scenes. Some of what you're hearing is exaggerated, some of it is misunderstood, and some of it is rooted in real policy changes that deserve careful attention. The problem is that fear spreads faster than facts. And in an environment where immigration enforcement has clearly intensified, it becomes very difficult to separate rumor from legal reality. So the real question is this: can your US citizenship actually be taken away in 2026? Are naturalized citizens being targeted? And what has truly changed under President Trump's renewed immigration agenda? Not politically, not rhetorically, but legally. Because there is a massive difference between campaign language, agency enforcement priorities, executive authority, and constitutional protections. And if you don't understand those differences, it's easy to panic and make bad decisions based on fear instead of law. Today, we're going to break this down clearly and calmly. What's new? What isn't new? Who is genuinely at risk? And what you should and should not be worried about right now. Hi, I'm Sophia, and welcome back to Us, Move, and Money. If you've been following this channel, you know that my goal is simple: to give you clear, legally grounded, and up-to-date immigration information without political spin, without sensationalism, and without fear-mongering. Important note before we dive in: this video is for general information only. It is not individual legal advice. Every case is different, and if you have specific concerns, you should speak with a qualified immigration attorney. Immigration law in 2026 is changing rapidly. Policies are being updated, enforcement priorities are shifting, court challenges are unfolding in real time. And when that happens, confusion spreads quickly, especially inside immigrant communities where people are understandably protective of everything they've worked so hard to build. So today, we're doing a full legal breakdown of the new rules and enforcement updates affecting naturalized citizens under the Trump administration. Not rumors, not speculation, the actual legal framework. Because once you understand how citizenship is protected under the Constitution, how denaturalization actually works, and what enforcement expansion really means in practice, you'll be able to replace uncertainty with clarity. And that clarity matters, especially right now: political messaging versus legal authority. Before we go any further, we need to separate something that almost always gets blurred together in public conversations about immigration: political messaging versus legal authority. President Trump returned to office on January 20th, 2025. From day one, his administration made it clear that immigration enforcement would be a top priority. Speeches emphasized border security, interior enforcement, and accountability for fraud within the immigration system. Executive orders directed agencies to review policies. Funding was reallocated toward enforcement divisions. Memoranda went out to field offices, changing how resources should be used. All of that is real. But here's what's equally real: campaign rhetoric is not the same thing as constitutional law. An administration can change enforcement intensity, redirect agency resources, reinterpret certain regulatory standards within the framework of existing law, but it cannot simply rewrite the Constitution with a press conference or an executive order. That distinction matters more than anything else in this conversation. When people hear that enforcement is increasing, they sometimes jump to the conclusion that rights are disappearing. That's not how the American legal system works. The executive branch enforces the law, Congress writes the law, and the Constitution limits both. So yes, enforcement posture has hardened in 2026. Yes, agencies like USCIS and the Department of Justice have been directed to increase scrutiny in certain areas. But the structural legal protections around citizenship, especially naturalized citizenship, are not political suggestions. They are constitutional guarantees that have been tested repeatedly in federal courts over decades. And that brings us directly to the foundation of this entire discussion. What protects a naturalized citizen in the first place? The constitutional foundation of citizenship. The answer begins with the 14th Amendment to the United States Constitution. It states in plain language that all persons born or naturalized in the United States are citizens of the United States. That phrase, born or naturalized, is critically important. It does not create two different tiers of citizenship. It does not suggest that one type is permanent while the other is conditional. The Supreme Court has repeatedly affirmed that once someone is lawfully naturalized, they stand on equal constitutional footing with someone born on American soil. Equal rights, equal protections, equal status under the law. Cases like Afroyim versus Rusk and Schneiderman versus United States have emphasized that citizenship is a precious right that cannot be taken away lightly. Courts have described denaturalization as something that requires the clearest justification and very strong evidence. Now, does that mean citizenship can never be revoked under any circumstances? No, and this is where nuance becomes essential. What is denaturalization really? There is a legal process called denaturalization. It has existed for decades. It is not new to 2026. Denaturalization is the formal process through which the government can attempt to revoke citizenship if it can prove that the person was never legally entitled to it in the first place. Notice the focus there, not on punishing someone for being a citizen, but on correcting a citizenship grant that, according to the government, should never have happened because of fraud or illegality during the immigration process itself. Under Section 340 of the Immigration and Nationality Act, the government may pursue denaturalization if citizenship was illegally procured or obtained through concealment of a material fact or willful misrepresentation. Let's unpack those terms. Willful means intentional, not a genuine mistake, not confusion, but deliberate. Material means important enough that it would have affected eligibility or the decision to approve. So we are not talking about minor paperwork errors, forgetting a short weekend trip, spelling mistakes. We are talking about deliberate deception that would have changed the outcome of the application. And even when the government believes such deception occurred, it cannot simply cancel citizenship administratively. It must file a civil lawsuit in federal court, present evidence, meet a high burden of proof, clear and convincing evidence. You have the right to hire an attorney, the right to defend yourself, the right to present evidence, the right to cross-examine witnesses, and the right to appeal if you lose at the first level. This is a structured judicial process, not a backroom administrative cancellation. Historically, denaturalization has been rare, extremely rare. For years, the number of cases filed annually was measured in the dozens, not thousands. Typical cases involved serious human rights abuses, undisclosed terrorism affiliations, false identities, clear marriage fraud schemes that led to green cards and then citizenship. The rarity of these cases reflects how seriously the legal system treats citizenship. Courts have consistently emphasized that stripping someone of citizenship is one of the most severe civil penalties the government can impose. It is not done lightly. So why the anxiety in 2026? If constitutional protections are strong and the legal standard is high, why is there so much concern in 2026? Because while the Constitution hasn't changed, enforcement intensity has. And enforcement intensity can shape how frequently these cases are investigated and brought to court. That's the shift we're seeing. Not a rewriting of citizenship law, but a more aggressive use of an existing legal tool. Understanding that difference is the key to evaluating your real level of risk calmly and rationally instead of emotionally. In other words, the foundation remains intact. The Constitution still protects naturalized citizens. The courts still require due process. The government still carries the burden of proof, but the machinery reviewing past cases is operating at a higher speed than it has in previous administrations. The next question, really the one that matters most, is how that increased enforcement plays out in practice and who it realistically affects. What has actually changed in 2026? Not the Constitution, not the statutory definition of citizenship. What has changed is enforcement posture inside federal agencies. Since early 2025, the Department of Justice has expanded resources dedicated specifically to denaturalization review. The specialized unit that handles these cases, which existed before, has reportedly received additional staffing, gained updated investigative tools, been directed to revisit older naturalization files where fraud was suspected but never pursued. At the same time, interagency data sharing has improved significantly. Government databases that once operated more independently are now more integrated. That means information from criminal records, immigration filings, asylum applications, visa petitions. Certain international databases can be cross-referenced more efficiently than in prior years. In practical terms, that means older cases are being re-examined with modern technology. Applications filed 10, 15, even 20 plus years ago can now be digitally compared against records that weren't easily searchable at the time. For example, if someone used a false identity decades ago and that identity now matches fingerprints in a criminal database, it can be flagged. If someone concealed a serious conviction abroad that later appears in shared international systems, it can be detected. The system is more technologically capable than it was in the early 2000s, and this administration has made it clear it wants those capabilities fully used. But here's the part that often gets distorted online. Increased review does not equal mass revocation. Even with expanded enforcement, we are talking about hundreds of denaturalization cases per year, not millions. The overwhelming majority of naturalized citizens will never receive a notice, never be contacted, never face a challenge to their status. The cases being prioritized tend to fall into very specific categories: individuals who concealed involvement in war crimes or human rights abuses, individuals who failed to disclose serious criminal convictions that would have made them ineligible, people who obtained green cards through proven sham marriages, applicants who used fraudulent identities or multiple identities, individuals tied to terrorist organizations or extremist groups that would have disqualified them if you were truthful on your naturalization forms, if you met the eligibility requirements, and if you did not hide disqualifying information, your constitutional protection remains intact. That is not political reassurance. That is legal structure. Denaturalization is about alleged fraud in obtaining citizenship, not about punishing someone for being unpopular, politically active, culturally different, or critical of the government. If this type of clear, fact-based breakdown is helping you understand what's actually happening beyond the headlines, make sure you're subscribed to Us Movin' Money and that notifications are turned on. Immigration enforcement policy in 2026 is evolving quickly, and staying informed through reliable analysis, not viral rumors, can make all the difference. Stricter vetting for new citizens in 2026. While denaturalization applies to people who are already citizens, another significant shift in 2026 affects those who are still in the naturalization process. USCIS has implemented more rigorous vetting procedures for new applicants. The civics test itself has not officially changed in structure, but interviews have become noticeably more detailed. Officers are spending more time reviewing travel history, employment records, tax compliance, prior visa and immigration applications. Requests for evidence, RFEs, have increased, especially in cases involving extended travel outside the United States, complicated immigration histories, past status violations. Processing times have also lengthened in many jurisdictions. Applications that once averaged 12-18 months are now in some areas taking 18-30 months or longer. That doesn't mean approval rates have collapsed. It means scrutiny has increased. Officers are documenting cases more thoroughly, conducting additional internal reviews, running more layered background checks. Here's something many applicants misunderstand. The test isn't harder, but the verification is deeper. Officers are paying closer attention to consistency. If information given at the interview doesn't match prior filings, even older visa or asylum applications, it can trigger follow-up questions or RFEs. That doesn't automatically mean denial, but it does mean preparation matters more than ever. Green cards versus citizenship, very different protections. For green card holders watching this distinction is critical. If you are not yet a citizen, your permanent resident status does not carry the same constitutional permanence as citizenship. Lawful permanent residents can lose their status under a broader range of circumstances than naturalized citizens can lose theirs. For example, certain criminal convictions, long trips outside the US that look like abandonment, misrepresentations on applications, tax issues, or claiming non-resident status when you're actually a resident. That's precisely why, if you are eligible for naturalization, applying for citizenship is often the strongest legal move you can make. Citizenship provides protections that permanent residency simply does not. But in 2026, if you are eligible and applying, you must approach the process carefully. Review your entire immigration history before filing. Make sure prior applications were accurate. Confirm that your tax filings align with your reported employment and residence. If there were complications, arrests, past violations, extended trips abroad, speak with an immigration attorney before filing your N-400 enhanced scrutiny. Doesn't mean automatic denial, but it does mean preparation is no longer optional. So we now have two parallel realities in 2026, more aggressive review of past naturalizations where fraud is suspected, more intensive vetting of new citizenship applications. Neither equals automatic loss of rights, but both reflect an enforcement climate that is stricter than what many immigrants became accustomed to in prior years. The broader enforcement climate. Why fear spreads. To understand the real level of risk in 2026, we need to zoom out and look at the overall enforcement environment, because perception is often shaped less by individual cases and more by the general atmosphere. Beyond denaturalization reviews and stricter naturalization interviews, the Trump administration has expanded several enforcement mechanisms that affect non-citizens. Expedited removal procedures have been broadened in some contexts. Workplace enforcement operations have increased. Cooperation agreements between local law enforcement and federal immigration authorities have been expanded in some jurisdictions. Now, if you are a naturalized citizen, expedited removal does not apply to you. Workplace raids are not designed to target U.S. citizens. Local police cooperation with ICE does not override your constitutional rights, but immigrant communities are interconnected. Many families are mixed status. A citizen married to a green card holder, a citizen with undocumented parents, siblings with different statuses. So even if the legal risk is limited to specific categories, the psychological impact spreads much more widely. People feel, if they are going after some immigrants, maybe I'm next. That's why clarity is so important. Because while enforcement has expanded, the legal threshold for denaturalizing a citizen is still tied to fraud or illegality in obtaining citizenship, not to your opinions, your ethnicity, or your culture. Who is actually at risk? Let's break this down precisely. Category 1, people who knowingly lied about something material during the naturalization process. Examples: failing to disclose a serious criminal conviction that would have made them ineligible, concealing participation in human rights abuses, hiding membership in organizations that legally bar eligibility. Material means information that would have changed the outcome. Forgetting a speeding ticket, not material. Concealing a past felony, very likely material. Category 2, people who obtained green cards through proven fraud, then naturalized. If your permanent residency was obtained through sham marriage or other fraud, and the government can prove that, then the citizenship based on that status can be attacked. Category 3, people who used false identities or fake documents. With modern biometrics and database cross-matching, identity issues are easier to spot now than 20 years ago. Multiple identities, altered documents, and fake passports raise red flags. Category 4, people tied to terrorism-related grounds or serious human rights violations that were never disclosed. These cases are relatively rare, but they are among the most aggressively pursued. Crimes after naturalization. Another major misunderstanding. Crimes committed after naturalization by themselves generally do not cause loss of citizenship. If someone becomes a citizen properly and then, years later, commits a crime, they may be arrested, be prosecuted, go to prison, but they do not automatically lose citizenship just because of that later crime. The exception is when the later investigation shows that the person lied during the naturalization process. For example, if it reveals criminal conduct that occurred before naturalization and was concealed. Again, the focus is always, did you obtain citizenship by fraud or misrepresentation? Myths you should ignore. There are several myths spreading online that we need to correct. Myth: speaking your native language at home can put your citizenship at risk. Reality: absolutely false. The law does not require you to stop using your mother tongue. Myth: traveling frequently to your home country can cause denaturalization. Reality: travel by itself is not a ground for denaturalization. It could affect certain tax or residency issues, but it does not cancel properly obtained citizenship. Myth: criticizing the US government can get your citizenship taken away. Reality: political speech, even harsh criticism, is protected by the First Amendment. There is no law saying you must agree with the party in power to remain a citizen. Myth: some nationalities are being stripped of citizenship in bulk. Reality: denaturalization must be based on individual evidence of fraud, not ethnicity or national origin. There is no statute that allows blanket denaturalization based on nationality. The honest picture is this: the vast majority of naturalized citizens who were truthful, met eligibility standards, and did not conceal disqualifying information are not facing a realistic legal threat. The people most vulnerable are those whose original applications contained deliberate, material deception. That is a much narrower category than social media suggests. What if the government contacts you? Now let's talk about the worst case scenario that many of you worry about. What if you are actually contacted about your citizenship? If you ever receive a letter from the Department of Justice, a notice from USCIS, a request for an interview or questioning related to your naturalization, remember this: you have rights. You have the right to remain silent. You are not required to answer questions on the spot without legal counsel. A calm, respectful answer like, "I'd like to speak with an attorney before answering any questions," is completely appropriate. You have the right to a lawyer. Exercising your right to counsel is not an admission of guilt. It is a protection. If you receive any formal notice, contact a qualified immigration or civil litigation attorney immediately. If denaturalization is pursued, it happens in court. The government must file a civil lawsuit in federal court. A judge oversees the process. There are rules of evidence and procedure. The burden of proof is on the government. You do not have to prove you deserved citizenship. The government must prove with clear and convincing evidence that you obtained it illegally or by willful misrepresentation. You can appeal. If you lose in district court, you can appeal to a federal appellate court. In rare situations, legal questions can reach the Supreme Court. The government generally doesn't get unlimited attempts. Principles like issue preclusion mean the same exact claim usually cannot be tried over and over if the government loses. Smart preparation, even if you're not worried, even if you believe you have nothing to worry about, being organized is simply smart. Keep all immigration-related documents in a safe, accessible place. Certificate of naturalization, copies of your N-400 old green cards, prior visa applications, approval, notices, any letters from USCIS or the State Department. If you naturalized many years ago and don't have copies, consider filing a FOIA request, Freedom of Information Act, to see exactly what was filed in your name. If you had any complex history, arrests, immigration violations, long trips abroad, consider a consultation with an experienced immigration attorney just to review your file. Never ignore official notices. If you get anything that even hints at your citizenship status, act quickly. Deadlines in legal processes matter. For green card holders, a special warning: never falsely claim U.S. citizenship on any form, whether it's a job application, voter registration, or benefit application. A false claim to citizenship can be one of the most damaging mistakes in immigration law and is very difficult to fix later. Is the American dream still accessible? Let's step back for a moment and talk about the emotional reality. For many immigrants, citizenship was not just a legal status. It was safety, stability, the end of years of uncertainty. So when people hear that old files are being reopened or that enforcement is intensifying, it doesn't feel like a technical policy shift. It feels personal and frightening. Immigration in the US has always been politically charged. Different administrations emphasize different priorities, but one thing has been consistent across modern history. The legal system operates through structure. The executive branch acts. The courts review. Congress can change the law, but usually slowly. We're already seeing in 2025 and 2026 that some immigration directives are being challenged in court. Some are narrowed, some are blocked, some go forward. That back and forth isn't chaos. It's the system of checks and balances doing what it was designed to do. For naturalized citizens, this matters deeply. Federal courts have repeatedly affirmed that citizenship, once lawfully granted, is one of the most protected statuses under American law. Judges do not treat denaturalization casually. For green card holders and applicants, the landscape does feel tougher. Longer processing times, more detailed interviews, more visible enforcement. But approvals are still happening every day. People are still taking the oath of citizenship every single week across the country. Families are still being reunited. Calm, routine approvals rarely make the news, but they are still the normal outcome for honest, eligible applicants. What this all means for you as we look through the rest of 2026 and into 2027, we can expect continued emphasis on fraud prevention and national security screening, more integrated data systems between agencies, ongoing court challenges that define the limits of executive power. Comprehensive immigration reform through Congress doesn't look likely in the short term, so most changes will continue to come from policy and enforcement priorities, not from brand new laws. But those policies still operate inside constitutional limits. So, what does all of this ultimately mean? If you obtain citizenship legally and honestly, your status remains secure. If you are a green card holder, you should prioritize compliance and consider naturalization when you are safely eligible. If you are applying now, preparation, consistency, and honesty matter more than ever. And fear-based rumors should not drive your life choices. Knowledge is stabilizing. Structure is stabilizing. Due process is stabilizing. The American immigration system in 2026 is stricter in tone than in some previous years, but stricter enforcement does not equal lawless enforcement, and it does not erase constitutional safeguards that have been tested and reaffirmed over generations. If you found this breakdown helpful, share it with someone who's worried and might be getting their information from panic-driven posts instead of from the law itself. I'm Sophia. This is Us, Move, and Money. Stay informed, stay prepared, and remember, if you got your citizenship the right way, the law is still on your side.